So today we have a couple of different people speaking from a couple of different perspectives here. And really the goal and the objective here is to take it a little bit deeper. And it's been for so long, actually I think 4 years ago is when we kind of thought outbound telemarketing was going to die once again. And so, we're still here, we're still doing it. We've been so focused on looking at compliance requirements that I really wanted to bring up the importance of looking at business requirements. So we brought a couple of different people to focus on different aspects of this. First off, starting off next to me is Eric McCaffery. Eric serves as Vice President of Business Development for Empereon Marketing Services. Eric, if you want to talk a little bit about your role at Empereon.
Yes, I've been with Empereon for about 12 years in the broadband space. Prior to that, I worked for Excited Home and Comcast in sales, marketing, event roles. So my role at Excited Home is to bring new products into the company with the campaigns that we have, expand, and make them more efficient for our clients and drive more sales.
Perfect, thank you. Sitting next to him, we also have Joseph Bowser. Joseph currently works as an attorney at Innovista. And Joe, if you want to talk just a little bit about your background there.
Yes, and everyone should please use Joe. I reserved Joseph for when I get speaking tickets. I founded Innovista Law a few years ago. I was down the street at a big firm in DC here, and I started as a telecom attorney, and in connection with our work with SMS and call platform providers, we got introduced to TCPA work about a decade ago, and that's taken on an increasing amount of our work.
Perfect, thank you, Joe. And then sitting next to Joe, we also have Mark Mallah. Mark Mallah is currently serving as the General Counsel for LiveVox. Many of you are very aware of who LiveVox is and have seen them quite a bit for the last couple of years at Pace. Mark also has a pretty interesting background. So Mark, if you want to give a quick kind of snapshot of your past.
Sure, well, I'm General Counsel for LiveVox, been there about 7 years. We deal with customers, their compliance concerns on a regular basis. We provide hosted contact center solutions, and very happy to be joining you.
Perfect, thank you. So, we were supposed to be talking about the recent updates and what they mean. We haven't gotten the updates, so we had to go back to Plan B. And, with everything that we've covered, it's hard not to be redundant. And I wanted to take a step back and just kind of look at the basics again and just really kind of understand who are the players you have to be looking at if you're doing outbound telemarketing in today's industry. So Joe, if you could just kind of talk about who you want to watch out for today and pay attention to what they're doing.
Sure. I wouldn't blame the folks here to feel outnumbered, because we've already met some of the folks who regulate the TCPA issues that you face on a daily basis. We've met the state AGs, we've met the FTC, and we've met a representative from the FCC. But we also have the 800-some federal judges who hear TCPA cases every day. Not only is it the #1 source of complaints at the FCC and FTC, it is the second most common type of litigation in federal court today. And it matters tremendously which judge you get. So for example, last week, there was a case where everyone's aware of the professional plaintiffs that are bringing TCPA cases every day. And they typically come in with what's called an informa pauperis, literally in the form of a pauper, where they want to waive the filing fee to start a federal case, which is ordinarily $400, $500. This judge took it upon himself to say, hold on now, you're telling me that you can't afford the filing fee, but I know that you filed 10 other TCPA cases and you settled all of them. So if I'm denying your application, you can send in another one and let me know how much you made on those 10 settlements, and maybe then I'll let you waive the filing fee. So, but every day, these things go unnoticed, stamped, approved, and then this guy is off and running into discovery and harassing their company, running up the legal bills. Similarly, there are cases where courts are tolerant or intolerant of the professional plaintiffs. There was a case in the Western District of Pennsylvania where the plaintiff admitted that TCPA litigation was her job. And the court said, that's not the kind of case that Congress was trying to create here. You're not supposed to use this as a money-generating business. And so that judge kicked that case out. That was a case against Wells Fargo. But a few miles down the road in Wheeling, West Virginia, that judge took a completely opposite view. That was the same setup. The person has 40 phones. They have technology that records the calls. They keep call logs. And then that judge said, well, she's doing exactly what Congress wanted them to do, enforce the law. So it matters tremendously which judge you get. And when you see the cases come in, it may be something to talk with your attorneys about what is the tenor of this particular judge with respect to TCPA cases. So we've got the state AGs, the FCC, the FTC, and 800 some federal judges, some of whom have very different ideological positions.
You know, it's interesting, Joe, that one case was really interesting because there was a level of shamelessness to it where I think the person said, "It's just my business. This is what I do. I sue companies under the TCPA," and she said it without any irony whatsoever.
Oh, absolutely. In her deposition, she said, yes, I have 40 phones. It is my business. And in her phone, she specifically tried to get Florida numbers, even though she lived outside of Pittsburgh. And the lawyer asked, well, why did you get all these Florida numbers? And she said, well, that's because companies prey on depressed people in Florida. And the judge is like, this doesn't fly in Pittsburgh. So.
Perfect, thank you for that. So looking at that now, it brings a whole different dynamic to our business where we're not just focused on who's most likely to buy our products, but really looking at, okay, how do we have to start off with all this data now? You know, what are we doing on this side? What are we doing on this side? Have we scrubbed it for this? Can we dial it on this platform? Do we have consent for these people? It's just a whole disaster almost, and it almost reminds me of like preparation for cooking, where you're getting out all your ingredients and deciding where they go, because if you put them in the wrong thing, it's not going to turn out the right way for you. So, you know, make a joke, you just want to talk a little bit about what you need to do when you start off with your data and, you know, what you might want to be able to assess before you start putting them in different platforms.
Yeah. Well, I mean, I like to kind of set out a Venn diagram and just think about it from a TCPA perspective, because you need to answer some fundamental questions about, you know, who you're going to be calling, what kind of numbers you're going to be calling, and what you're going to be calling them about, because as the FCC representative explained earlier this morning, all of those are inflection points under the TCPA about the type of technology you can or can't use, because if you're going to be calling a mobile or increasingly a VoIP line where that customer is charged for the call, and I treat those calls as a wireless call versus a landline that's not going to get an auto dial or a pre-recorded artificial voice call. But those are different technologies that you want to segregate. And so too, you have to ask yourself, what kind of call am I going to make? Is it informational? Is it telemarketing? Or could a court think that it's blended? A lot of times I have clients who come and say, well, it's just a post-sale survey. I want to know how I can improve. And courts have been pretty suspicious of those if they think that, well, sure, the point of that call isn't to generate a sale, but if the point is to generate your customer loyalty and get them back in the door more quickly than they otherwise would, some courts will say, well, no, I'm going to lean towards the side of a promotional call. And so you want to be thoughtful about how you're calling and what you're calling about before you make those technical choices.
Sure. Mark, did you have anything that you wanted to add to that?
No, I think that covers it pretty well.
Okay, perfect.
And the one thing from a scrubbing perspective, from a vendor perspective, as you get files from your clients, they get it from their data warehouse companies. Make sure you also do the scrubs yourself, because there could be pieces missing from or data that's old. Some data warehouses buy their list and they're not online. So it's always good to redo a scrub. We had some instances where our scrub loss rate was about 12% loss between gross and net. Other vendors were running at 5%. So it came to have a discussion on, well, what are you scrubbing that the other folks historically are not scrubbing? And it bubbled up that there was some checkpoints missing from the data that was coming in. So by doing a double scrub, you can find issues before you actually make the call and then you get into litigation.
And that's a great point, Eric. From contact center compliance, we work with these people all the time, and one of the biggest things that scares me is I see all these people that are doing the, oh no, it's an opt-in, and we're buying these leads. And I'm like, well, is your company disclosed where they're opting into this? And there's a lot of areas where people are buying these internet leads and taking them out there and taking the person that purchased them's word for it, when it's actually them who are going to be sued if they didn't follow the rules that they said that they did. So that's an excellent point. I appreciate that, Eric. First you have the data, you're deciding where it goes, and then you get your technology, platform and environment. You're looking at that, and it's so different now. Again, you're not looking at it on what's going to fit my business needs. You're looking at it on, is it a non-automated telephone dialing system? And there's got to be different perspectives for different people in your organization. And I think one of the biggest things is coming from the legal counsel. Mark, when you're looking at that, you're not necessarily looking at if it meets the requirements as much as how can I defend this? Can you talk a little bit about how you need to really approach when you're doing a vendor selection for that and how you need to look at that?
Well, if you mean like defending TCPA in general, I think that you want to have two lines of defense. You want to make sure you've got the best consent that you can possibly have, and you also want to make sure that where possible you're using a non-ATDS if you're not sure about consent. And with respect to consent, I think that the cases that I've seen out there, it's very particularized the way the judges and the courts are looking at consent. The plaintiffs are always going to look for that seam where, you have the consent, but there's some kind of opening, like it's partial, or you only consented for that particular week, or about this particular issue and not that issue. So I think, you really want to make sure you've got good broad consent, so you kind of blanket the field, and the plaintiff can't come in and find that seam where they didn't give consent, because they're always going to look for it. And then the other thing is revocation of consent. When the FCC came out in 2015 and said, hey, you can revoke your consent by any reasonable means, that's just so wide open. And I think it's easy to feel like, well, we're really vulnerable to revocation of consent. And in some ways you are. But I think, what I suggest is that you can help define what reasonable is. I don't think you need to leave it a blank slate. So for example, if you say, hey, if you want to revoke your consent, you can call this number. You can email this email address. Or you can text here. And you suggest those revocation channels. If a consumer then chooses not to use one of those channels, but like walks into a store and tells some clerk, I'm revoking my consent, it starts to look unreasonable because you told them, some easy ways to revoke consent, and you chose some other way that was, not one of the suggested paths. So I think you can help define what reasonable is. I don't think you have to be passive about it. And then with respect to, so that's the first line of defense. I've seen a lot of cases out there where companies just have one line of defense, and that's consent. And consent can be compromised. The burden of proving consent is on the caller, so you've got to have really good records. And I think it's a little easier for plaintiffs to sort of compromise that. So I think you got to have your best consent, and then behind that consent, have a technology defense. You're using a non-ATDS. Maybe using 10-digit entry. I don't think there's any cases out there where there's 10-digit entry and it's found to be an ATDS, even with the potential capacity issue. I think it's pretty hard for a court to say, yeah, well, you entered all 10 digits, but it's still an auto dialer. I don't think there's any cases. And even, I think, one of the panelists said yesterday, the point and click, there's a lot of good point and click cases out there. Single click, been found to be sufficient human intervention. FCC in 2015 said speed dialing, which is like a single click, is not the sort of problem we're looking at. So I think you want to have a good consent defense, and you want to have strong technology behind it, so that you're presenting a pretty formidable path for the plaintiff to climb in order to surmount both. So that would be sort of my main suggestions.
Or if I could amplify the point Mark just made, consent's not just important for the claim that particular plaintiff is bringing, but if they're bringing their case in a class action capacity, when you can get consent to be a key issue that would drive a wedge between that plaintiff and other class members, it makes the courts very reluctant to certify the class, in which case you're left with just dealing with that particular plaintiff's claim, which is invariably going to be a lot cheaper than dealing with that claim multiplied across your entire calling list.
Sure. In other words, like defeating the class.
Defeating class cert, exactly.
Yeah.
So, Joe, maybe you can just expand a little bit. Mark just talked a little bit about how you can kind of look to defend from a legal perspective if you're protecting your company, but if you're trying to go out there and you're looking for a platform that's a non-automated telephone dialing system, well, what would you recommend to people from a compliance aspect on how to actually select it, what type of criteria they should be looking for?
Mm-hmm. Well, Mark's right. The cases have centered around the extent to which there's human intervention and the kind of evils that the TCPA is meant to cure, right? So certainly predictive dialers and auto-generated dialers are you should steer clear. So the greater extent of human intervention and separation between, if there is an auto dialer in play for landlines, and the agents who are making the calls to wireless numbers, and if you're including them in VoIP numbers, you want to make sure that there's a clean break between those two systems, so that you can show in discovery that there's a clear line between those two.
Yeah, and you should have it documented in a diagram, and also probably have an opinion letter. Also be able to show how your lists are broken out between wireless and landline. The more data that you can gather for the discovery just helps build the case.
Absolutely. And they're going a little bit more on that. I mean, from a business perspective, okay, great, it meets all the compliance requirements, but we still have that thing called productivity. So, you know, like, how do you manage it? I mean, there's been so many new things that have came up. We've got 5 years of data. You know, a while ago, we were talking about 30% decrease in efficiency. Then people were saying they were getting higher conversions. You know, there's a lot of different stuff going on, but literally there was things that, you know, appeared that as a result of not having all the bells and whistles, that were kind of harder to manage the business. How do you look at making sure it meets the requirements for your team to still be able to satisfy your customers' needs?
Well, it comes down to need to enhance your workforce management team to be able to monitor the agents if they're done on landline or wireless, when they're going into those lists. You know, maybe wireless, landline is more evening, wireless you can spread it out more during the day. You know, you're identifying their idle time because it's up to the agent to launch the call. So you manage, if you see their idle time going up, then the supervisor needs to go over and talk to the agent. So it's a lot more hands-on on the wireless side to make sure they become efficient, to make sure they're dialing and launching the calls. One positive thing with dialing the wireless versus using the dialer is that the call connects right away, versus sometimes on the dialer, there's a little delay of the connection. So a lot of times you'll get less hang-ups on a wireless because it's connecting directly to the customer. So there is a little bit of a positive.
Well, Eric's absolutely right, that documentation is key, because when it's just information that you learn in a deposition, it's harder for the court to say, okay, that's enough evidence to give this company summary judgment. But if you document what you're doing at the time you're doing it, that's admissible evidence that's, you know, that of course is going to say, okay, well, the plaintiff doesn't have anything to rebut that. This is really all we have, and I'm going to say that this is enough to kick this case out.
Yeah, I would, just to add to that, you know, the documentation is key, and in creating the documentation, I think, you know, you have the opportunity to paint the picture and create the presumption, you know, that it's not an ATDS, and let the plaintiff rebut and try to contest that. So I think it's, you know, it's really important to take the initiative, paint the right picture, you know, include all the elements you want to include, and don't just kind of leave it to chance. You know, when you get to court, you know, based on a deposition or, you know, someone's testimony, really be proactive about it.
Because from the plaintiff's attorney's perspective, they've got a stable of cases. These guys have apps to attract TCPA plaintiffs, right? I mean, so they're looking at this from a portfolio perspective. And if they have to look like they have a done case against you, you're going to start to get the email, hey, why don't we settle this one? And you can get it done for cheap. But if the documentation is muddy or non-existent, you look like a pretty good mark.
Sure, yeah, absolutely. And that brings up a great point. I think it's, Eric, from your perspective, and you kind of brought it up and hit on it a little bit earlier, but you know, you're going a lot of times with what your customers are providing to you and what they're telling you has already been done. And you know, now really when you're looking at it, going back from the data part, you know, you're getting express consent, but are you validating that person's still that person? And you know, how are you looking at your customers to know that they have a buttoned-up process where they're actually, you know, maintaining all of this information on hand, and then you're going and authenticating some of these things to make sure they're still the people. What does that look like from your perspective?
So we get the data come in and do our scrubs, and we push it out on the dialer. You'll kind of watch your wrong numbers. If you get a higher percentages than normal of wrong numbers, you'll start pulling those leads, maybe send it back to the client, have them do a scrub again, or take a look and see if there was some matching that was not accurate. A lot of times on a acquisition file, they could get a new feed, and that feed could be completely, you know, off. I mean, you're really, for our business, we are trying to reach the house, and a lot of times the name and the house don't match because the name is there's not a name. So we always try to validate that we're talking to that house, that address. And if that's wrong, it comes down to the agent's disposition. The better they can disposition, the better we can get it back to the client, they can get it back to the data warehouse, and they can clean up the list.
Okay. And Joe, from your perspective, if I'm making calls for ABC company, what would I want my client to provide me if they're telling me they have express written consent?
Well, if it's in writing, you could see it.
Right, but what are some forms that they could show me that?
Oh, well, I mean, they can get online enrollments, point of sale enrollments. The form of writings, they can be electronic, they can be printed.
Sure.
You don't need to see all of them, of course, but once you've satisfied yourself that they actually have a practice of gathering prior express written consent for the telemarketing, pre-recorded and artificial voice calls.
Sure, and when you see people doing that, of course you have to then go through the reassignment for that. And how are you dealing with reassignment, and what are people doing from, if maybe their kid's phone is underneath their name, or it's the husband's paying the bill, but it's the wife's phone, or, it's a burner phone, and those types of things. I mean, how are you looking to try to confirm and track these types of things?
Well, that's hard. I mean, when it's reassigned to a stranger, we all know that it's a strict liability statute in a world where it's impossible to comply perfectly. But when it's close like that, the courts tend not to get bothered by that. If you call and the roommate picks up the phone, or the daughter picks up the phone, the courts say, there's no way that these folks can do this. You're not going to get class certified on that basis anyways. So it would be a small infraction.
Sure.
So I think they're just kind of figure that.
Perfect. Okay, great. So, talking about a couple of recent court cases, we've talked about a lot here going on, but Mark, maybe you can talk a little bit to us about Mark Jenkins versus McCage.
Sure. So, wanted to just highlight this case. I think it's a pretty interesting case. It was decided in 2016. It's Jenkins versus Engage or McCage, I'm not sure. So this was actually a reassigned number case, and it's also a text case. And I think it's pretty interesting because what happened there is that the number was reassigned by one consumer to another, and the number that it was, the person whose number it was reassigned to told the caller, stop calling. It may not say reassigned number, basically stop calling, continue to tell them to stop calling. I think they responded by text or something, but in any case, the calls did not, or the texts did not stop. And when the plaintiff sued, said, hey, you're texting me on an ATDS here, and you've got basically TCPA liability. Well, it was decided on summary judgment, and the court found that Engage was not an ATDS. And the reason was because the texting party basically created the message that was to be text, uploaded the message onto Engage's platform, selected the time that the message was to be sent, uploaded a list of numbers to be texted to. So you had all these elements of human intervention, and then clicked to launch the text. And the court found that all those sort of steps of human intervention rendered that system not to be an ATDS. And it was particularly interesting because they had the ability to load 10,000 to 50,000 numbers at a time. So you have a situation here where you have this antecedent human intervention, and at a single click, you could launch 10,000, 50,000 numbers at a time, and the court still said, not an ATDS. So I thought that was pretty interesting. And there was one other case I just wanted to highlight, Shiver versus Bayview. And the interesting thing I found there is that, the plaintiffs alleged the use of an ATDS and said, you have all this automation. You've got this answer machine detection where you've got this pause. You've got a automatic call distributor. You've got IVR systems in place. You have all this automation. This has to be an auto dialer. And the court said, no, it's not. Just because you have all this surrounding automation doesn't mean that the system you're using is an auto dialer, because there's still sufficient human intervention. And the last interesting thing I think about both of these is that it was a human intervention piece that really determined the case. And the court never really looked at the potential capacity. I know there's a lot of anxiety about potential capacity, and rightfully so, given the 2015 ruling. But I have not seen the courts, Joe, and you guys, I'm not sure what you've seen, but I have not seen the courts sort of conduct this potential capacity analysis, look deeply into this very amorphous standard. I think they've really focused on the human intervention piece. Again, you should not be concerned about potential capacity, but I just have not seen the courts embrace it.
I think that's fair. I think it's harder to win on the motion to dismiss now because of that, because the courts are looking at that as the legal standard that the plaintiff has to plead against. But on summary judgment, the courts are taking a much harder look and saying that there has to be some reasonable limit to what an ATD has, because it can't be that we're all carrying one in our pocket.
Thank you, Mark. And Joe, I know we've been talking about revocation of consent in some of those areas as well, but I know there's a particular case that we were talking about a little bit ago that I think would make sense to kind of talk about following up with Mark around the revocation circuits.
Yeah, sure. Well, there were two important circuit court cases. Circuit courts are the courts between the Supreme Court and the district courts that deal with revocation. The Second Circuit in June held in the Reyes case that if you give your consent to be called as part of a written agreement, you can't revoke that consent in any form because it was part of the deal. So Reyes had a lease for his Lincoln car, defaulted, they called him over 500 times, and he said he revoked his consent to be called. And so they sued them for $720 grand under the TCPA. And the Second Circuit said, you don't have a case, you couldn't revoke your consent. You gave them consent to be called as part of the contract, and they can't come and take your Lincoln any more than you can say, I'm taking my consent. But so that's good for the industry. I query whether I hang my hat on that if I get a DNC request. But in any event, heading to Crazy Town down in the 11th Circuit in Atlanta, there's the Schweitzer case that you've probably all heard about, where this woman gave this garbled response to the agent that said something like, she's probably like under the table at work or who knows, but she said, if you're calling me in the morning and at work and it's hard to talk, and that was kind of the end of the call. And then 5 months later, she said, you need to stop calling me. They get put on the DNC list, they don't call again, and soon thereafter she sues for all of the calls between the garbled conversation under the desk and when she actually said, don't call me anymore in English. And the 11th Circuit said, well, it's possible to partially revoke your consent. So if she doesn't want to be called in the morning, in the afternoon, or when it's raining or sunny, you should honor that. And if that's too hard for you to do, maybe you just shouldn't call her. So they reversed the trial court and sent it back for a trial to find out whether the jury thinks that she partially revoked her consent, because their view is, under the common law, you can give consent and put parameters around them. So if those are her parameters, why can't she do that? So we have a case where there's a contractual form of consent that you really can't revoke, at least in the Second Circuit, which is New York, Connecticut. And then in the 11th Circuit, callers beware, because apparently now you can put any form of restriction on your consent, and it's on you to figure out whether it's worth the risk.
Joe, I got a question about that. That New York case where they said, you can't revoke your consent, it's part of the benefit of the bargain. You can't unilaterally revoke a contract term. So again, I'm always looking for the proactive approach here. Could companies then say, okay, hey, this is a great case. So going forward, when I ask you for your consent, I'm going to explicitly say, hey, your consent is, material inducement to me entering into this relationship with you. I consider it part of the benefit of the bargain, and this is an important contract term. Please provide your consent and set yourself up so that you've made it clear that this is part of the benefit of the bargain. Advisable, too aggressive?
Well, that sounds like a red flag to me, because the definition of prior express written consent in the FCC's regulations say that consent can't be a condition of purchase. So I worry that that kind of consent all of a sudden violates one of the conditions of consent under the FCC's rules, which would make the consent invalid, in which case all of your calls may be valid, not just the ones before she revokes.
But doesn't the New York case go against that then?
It wasn't stated as a condition, it was just one of the elements of the bargain. So he didn't say, Lincoln rather didn't say, you can only get this Lincoln if you consent.
I see.
It was just one of the terms.
Yeah,
There it is.
right. No, that's a good point, good point.
So I,
Because that's unilaterally changing a contract. So, I don't think you could. Would you agree in that situation?
sure.
And then, but the other thing too, again, you said this earlier, one of the first things you said, that's one court, or one circuit. So, again, all of this comes down to risk mitigation. If you're in another court, another circuit, they may not like that New York case.
Can you hear me now?
Yes.
Okay. Thank you, gentlemen. Quick question, there's a lot of off-taking lead generation online, and my company has seen pretty much every aspect of that over the last 5 years. When we get that complaint comes in, and we've all seen it, we've all experienced that. There's required evidence, show us what you got. So you have an opt-in program online, and a typical page will say, consent to call by so-and-so company for trusted partners or what have you. And now we're months down the road and someone wants to see your evidence. How is that packaged and presented? Or what is actually given as the written consent evidence thereof in cases like that?
I didn't understand.
It sounds like when you get the,
So you have an online webpage, and it says, hey, I'm going to give consent to blah, 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 blah. Check the box. Here's a page. Here's my name, phone number, so forth and so on. Here's my e-sign disclosures, by the way, all this. Okay, so we're down the road, and that person files a complaint, and you need to present evidence of prior express written consent. Well, obviously, you're not going to carry a webpage in the courtroom. And webpages, by the way, are dynamically changing all the time. So what gets snapshotted, and in what form is that presented as physical evidence?
So you'll take a Wireshark or a screenshot of whatever the website looked like at that time, and then keep a track of when it changes. It ideally doesn't change too often. And then you'll have the database behind that collects all of the contact information, and you'll have a witness from the company explaining how the website's maintained, and how you collect the data, where it's stored, that it's good data, and it'll be presented to the court or as evidence.
And just to expand on that question, have any of you had to present a package of data like that, or had any experience doing so?
Sure.
yeah, we've had to submit recordings, call logs, IP addresses, everything.
Often an expert will bundle it up and explain it in plain English.
The diagram of how we got wireless versus landline and where the separation is. We've had to submit that.
I've had very senior judges get it. It's part of the common experience. They understand that people can sign up for these things online. And, you mentioned trusted partners. That one made me a little nervous if you're the trusted partner, but the courts get it.
Thank you.
The database is content.
If I could just add to that, and I think implicit, Joe and Eric, what you're saying, it's a business record. And as a business record, you can demonstrate, that you've recorded the consent. But I think you can potentially go even further and come up with some sort of policy or procedure in writing, like this is the way you record your consent, this is the way you track it. And I think that makes it easier to prove the fact that, hey, you have an established procedure in place, you followed the procedure, and it's recorded in your CRM or somewhere that this person consented. It becomes pretty difficult to rebut that. And again, I would encourage like some sort of written policy or procedure and testimony that, yep, this is what we followed in this case as well. Again, difficult to rebut that.
Just taking that one step further, how long, from a digital recording or an online consent type, how long do you want to keep the recording after you're done calling that person and that documentation on file just to be safe in case anything comes up afterwards down the road?
Well, you got a 4-year statute of limitations, so you certainly want to do that.
Sure. Once you're done calling them, though, correct? Not just 4 years in general. If you're calling them ongoing, then you keep it forever.
Yeah, from the last contact.
Yeah.
And if you keep stuff forever, keep it forever. Because you never know when it's going to bubble up.
Question,
Any more questions?
On that same issue, what do you think about trusted partners in the language versus specific company names?
The latter is far preferable. Because then you know who you're giving consent to.
I think a lot of internet news sites use the trusted partner language. Has that been challenging for it at all?
Okay.
A lot of the internet news sites use the trusted partner language and do not list specific companies. Are you aware of any cases that have occurred that might give us some insight on that?
Not off the top of my head, but they probably lost.
Okay.
Joe, you mentioned earlier that on the Reckless voicemail petition, one was pulled. Could you share with us why?
You go to the FCC, you have ex parte meetings, and you talk to them about it. The most recent one wasn't ours. That was all about the messages. That was the most recent one, and it was pulled probably 4 months ago now. But when you ask the FCC for something and then you withdraw your request, the inference is usually pretty good that you weren't going to get an answer that you like.
Thank you.
You know, I just want to ask Eric this, or and Joe, John, for that matter. We talked about storage, storage of call recordings, storage of records. We have a lot of conversations with our clients, how long should you store it? So one of the concerns I have is that certainly you want to protect yourself and store it for the prior 4 years with TCPA because that's a statute of limitations. The concern I have about storing it longer than that is that it's outside the statute of limitations. If you get sued, in a class action case, and you've got all these records going back, you're going to have to produce them. And you could be helping the plaintiff's attorney create their class going back more than 4 years. I mean, I guess you could argue that it's beyond the statute of limitations. But just in general, even within 4 years, is there an obligation? What if you only have 2 years and that's your data retention policy and we start with 2 years? So if you want to go back 4 years, we can't, plaintiff's attorney, we can't help you. You only have the last 2 years, sorry. Would there be a problem with that? Or would you be helping yourself? What do you think?
Yeah, I think just from however long you keep it, you gotta keep it the minimum, so you're within the rules. But, I guess sometimes keeping it longer can help you, because maybe somebody's making false claims against you, so it can help you that way.
Right.
The other way, I guess, it can also hurt you. If somebody subpoenas your server and pulls all the data out of there. So I guess it can go either, kind of go either way.
Yeah, you're right, it's a double-edged sword, but and you mentioned this earlier, Mark, consent is your burden to prove. So if you don't have the records, how do you prove it?
Yeah, that's a fair point.
So I'd rather be able to prove my defense than slim down the class.
Yeah, it makes sense.
Right, and there's a lot of third parties as well. Especially with recent events going on in parts of Florida really being devastated there, you gotta have some backup, you gotta have some redundancy, you gotta have a continuity plan and have some type of disaster recovery where you're doing data dumps. Storage is so cheap now these days that it just, why not go the extra mile for a little bit more and not put yourself in a vulnerable situation? You're going through that process where you're storing the consent, you're authenticating the person, still the person, you're doing all these different things. Why wouldn't you just have it sitting there for a little bit longer? From that perspective, this would be my recommendation.
One more question?
All right, well, thank you, gentlemen. We appreciate it so much. Thank you for your insights today.